Exam Scholar, Real Estate Edition.
Question 1. If the expiration of time has passed in regards to the communication of acceptance by the seller from the buyer, this offer is considered A. Terminated. B. Valid. C. No longer an offer. D. None of these. Answer A. One way to terminate an offer from a buyer by a seller is to let the time expire on terms of acceptance. Question 2. In real estate, the offer to perform on the terms agreed is called A. Tender. B. Performance. C. Negotiated. D. Acceptance. Answer A. An offer by one of the parties to a real estate transaction to carry out that party's part of the contract is called the tender. This typically takes place at the end of the transaction. Question 3. If one party cannot perform their part of the agreed terms of a contract, the victim party can claim the other party. A. Performed negligently. B. Defaulted. C. Is voiding the contract. D. Is causing interference. Answer B. If a party cannot perform their part of the agreed terms of a contract, the other party can claim the other party defaulted. Question 4. If a party was discriminated against, they could A. Bring private action through a state or federal court. B. Bring criminal action through a state court. C. Bring criminal action through a federal court. D. Bring civil action through a state court. Answer A. Because discrimination is not considered a criminal act, the option of the party would be to bring private action through a state or federal court. Question 5. If a buyer of a property wishes to move into the newly purchased home before the close of escrow, the agent/broker should A. Allow it. B. Deny it. C. Obtain written consent from the owner. D. None of these. Answer C. Because the home has not closed escrow, it is still owned by the current owner and therefore the agent/broker must obtain written consent to allow the new buyer to move in before the close of escrow. Question 6. A legal cause of action in which a binding agreement or bargain for exchange is not honored by one or more of the parties to the contract by non-performance or interference with the other party's performance is known as A. Breach. B. Non-disclosure. C. Voidable. D. None of these. Answer A. Breach of contract is when one party does not honor the agreed upon terms of a contract by non-performance or interference with the other party's performance. Question 7. A clause that states a lender may demand the loan amount plus accrued interest in the event of a sale is called A. Addendum. B. Non-performance. C. Acceleration. D. Alienation. Answer D. The clause in which a lender may call in the loan plus accrued interest in the event of a sale is known as alienation. This is different than an acceleration clause in which the loan can be called in due to non-performance of contractual duties, such as not paying mortgage payments. Question 8. What type of arrangement is a less than freehold estate? A. Owner/tenant. B. Tenant/sublessee. C. Lessor/sublessor. D. None of these. Answer A. A less than freehold estate is an owner/tenant arrangement. Question 9. If an as-is clause is inserted into the sales contract for a property that seems to be generally okay on the outside and inside, this would be A. Allowed. B. Disallowed. C. Allowed only in cases of obvious defects. D. None of these. Answer. C. The only way an as-is clause is allowed in most situations is if there are obvious defects that any prudent person could discover. Typically they are disallowed by the real estate commissioner to protect consumers. Question 10. If one is transferring or conveying title to real property, it is called A. Alienation. B. Alluvion. C. Accretion. D. Succession. Answer. A. The term alienate in real estate means to convey or transfer.
Passing the real estate exam can be hard, like really hard. Statistically, only about 50% of people actually pass the real estate exam on their first try. Those people that pass, they go on to become real estate agents. And the people that didn't pass, they either give up completely or have to try again. Both of these options are painful, disappointing, and upsetting. Exam Scholar Real Estate Edition has been named as the best real estate exam prep by multiple publications for 7 years in a row. If you are about to take the real estate exam, Exam Scholar Real Estate Edition is a no-brainer choice. There is no other real estate exam preparation service out there that comes close. To enjoy the longest membership time, lowest cost, real estate videos, audios, articles, flashcards, vocabulary, exam tips and tricks, a 1-year no questions asked refund policy, and be one of the 35,000 people that it has helped pass the real estate exam, then sign up in less than 5 minutes at www.realestateexamscholar.com.
Question 1. During broker Shaw's preparation of the exclusive authorization and right to sell on seller Norman's property, Norman asked that a clause be included which would require the buyer to accept primary liability in connection with when the existing loan is transferred to the buyer. Shaw should enter which of the following in paragraph 2 of the exclusive authorization and right to sell? A. Buyer to take the property subject to the loan. B. Buyer to assume existing loan. C. Buyer to pay all cash. D. Buyer to make a large down payment to preclude possibility of a foreclosure. Answer. B. If a buyer assumes an existing loan, he accepts primary liability for that loan. Question 2. A third party who takes a promissory note that is complete and regular and has no knowledge of any defects is known as A. An endorser. B. A maker. C. A payee. D. Holder in due course. Answer. D. The party that accepts the endorsed note from the original payee without knowledge of any defects is known as the holder in due course. Question 3. The owner of a single-family residence plans to sell and wants to obtain an FHA appraisal to permit a sale with FHA financing. He should A. Contact the nearest FHA office for an appraisal of this property. B. Have a lender apply for a firm commitment. C. Have a lender apply for a conditional commitment. D. Submit a recent appraisal of his home to FHA. Answer. C. The recommended process for the lender to contact FHA for a conditional commitment, that is, for advance assurance that an FHA loan will be made, establishing the loan value for the house. Question 4. A buyer defaults in making payments on a loan, therefore the lender's action probably would result in A. Subordination. B. Escalation. C. Acceleration. D. Alienation. Answer. C. Acceleration indicates the right to declare the entire sum of a note to be due and payable immediately. Most trust deeds contain several acceleration clauses. Most common states, if you become delinquent in the payment on this note, the entire sum of the note becomes due and payable immediately. Other states, The entire sum of the note is due upon the sale or transfer of the property triggered by the sale of the property and therefore is a specific acceleration clause. The rule is, alienation clauses are types of acceleration clauses, but not all acceleration clauses are alienation clauses. Question 5. Which of the following is the classic definition of the boundaries of real property? A. A surface area indicated on a map. B. A reasonable use of airspace and extended to the center or the earth. C. A reasonable distance down and unlimited airspace. D. A practical or reasonable use of the earth and unlimited airspace. Answer. B. The surface of the earth and the material beneath the surface to the center of the earth is part of the real property. Since airways are now public domain, the ownership of airspace is used to an enjoyable and reasonable height. Question 6. A buyer defaults on a loan, therefore the lender would be able to cause the promissory note to become due and payable. This clause is A. A subordination clause. B. An escalator clause. C. An acceleration clause. D. An alienation clause. Answer. C. Acceleration clauses are several different types and reasons. Question 7. In general, when the supply of a certain commodity increases, A. Price tends to rise. B. Price tends to drop. C. Demand for it tends to rise. D. Demand for it tends to drop. Answer. B. If demand is constant and supply increases, sellers compete with each other by lowering prices. Question 8. An offer to purchase real property was signed by a prospective buyer on October 2, 1977. The terms of the offer allowed 5 days for acceptance by the seller. Because of an illness in the seller's family, the seller did not accept the offer until October 10, 1977. Which of the following statements is correct? A. The buyer may demand the return of his deposit. B. The buyer must continue with the purchase because he did not withdraw his offer prior to acceptance. C. If the buyer does not complete the purchase, the seller is entitled to the deposit. D. If the buyer does not complete the purchase, the seller and the broker will each be entitled to 1/2 of the deposit. Answer. A. This constitutes only an offer, and one method of terminating an offer is the expiration of a specified or reasonable length of time for the acceptance to be communicated. Question 9. An offer by one of the parties to a real estate transaction to carry out that party's part of the contract is called A. Gratuity. B. Satisfaction. C. Recourse. D. Tender. Answer. D. Usually made at the conclusion of the transaction, the tender is the offer to perform on the terms agreed to. If the other party cannot perform, then the party that made the tender can rightfully claim the other party defaulted. Question 10. Should a person be discriminated against, what would best describe the actions available to them? A. Private action in a state or federal court. B. Civil action in state superior court. C. Criminal action in a state court. D. Criminal action in a federal court. Answer. A. As discrimination is not a criminal act, we would eliminate answers 3 and 4. 2 is incorrect as the remedy available to the injured party is not limited to only action through a state court. It could take place through the federal courts. Question 1. Under FHA standards, the minimum ceiling height for a single-family residential construction is A. 7.5 feet. B. 8 feet. C. 8.5 feet. D. 9 feet. Answer. A. Although most ceiling heights are 8 feet, the FHA minimum requirement is 7.5 feet. Question 2. Real estate assets are usually acquired by using A. The results of long-term and short-term gains. B. The supply and demand of equity capital. C. Equity funds and money market funds. D. Debt funds and equity funds. Answer. D. There are mutual funds and real estate investment trusts that do acquire real estate assets, either debt assets, mortgage assets, or equity assets, ownership assets. Question 3. From a historical standpoint, the major function, objective and aim of the FHA program has been provided by A. Title I. B. Title II. C. Title III. D. Title IV. Answer. B. The largest and most important activity of FHA is the insurance, under Title II, of mortgages for home purchase and construction. Question 4. Examples of negotiable instruments are as follows, except A. A mortgage secured by a promissory note. B. A draft. C. A check. D. An installment note. Answer. A. The note is negotiable but not the mortgage. Question 5. A form that is usually prepared to allow a real estate licensee to act as an agent for all principal parties to the transaction involved is A. An agreement of sale. B. An exchange agreement. C. A loan broker's statement. D. A real property security statement. Answer. B. Under an exchange agreement, the real estate licensee acts for both parties. This is one instance where he could earn a commission from each party to the transaction. Question 6. The hiring of a specialist in property management would be justified by A. Absentee ownership. B. Technological advances in building concepts. C. Vacancy factor higher than normal. D. Urbanization. Answer. A. In absentee ownership, the owner lives away from the property and is not able to adequately supervise it. Question 7. Which of the following is not one of the four important elements of value? A. Scarcity. B. Appreciation. C. Utility. D. Transferability. Answer. B. The four elements of value are utility, scarcity, demand, and transferability. Question 8. Madison is a mortgage loan broker. When setting up a loan, Madison differs from Carter, a mortgage banker, in which of the following ways? A. Carter is authorized by law to make larger loans than Madison. B. Madison is exempt from the Finance Code. C. Madison does not normally use his own funds in arranging a loan. D. Carter deals primarily in loans which must be recorded. Madison's loans are normally not recorded. Answer. C. A mortgage loan broker normally does not loan his own funds, but negotiates the placement or sale of a loan with a particular lender. A mortgage banker generally has the funds with which to make a loan. Question 9. The following are correct statements concerning an option, except A. The optioner must perform if the optionee exercises his option within the period specified. B. The optionee must perform if the optioner exercises his option within the period specified. C. To exercise the option, the buyer must pay the amount specified in the option. D. The consideration for granting the option must be actual. Answer B. The question is a negative question asking for a false statement concerning options. Answer 2 states, the optionee must perform, which is false. The optionee receives and the optioner must perform. The optionee is the one who exercises the option. Answers 1, 3, and 4 are all correct. Regarding answer 2, there must be some consideration. It may be money or an act. In a lease option, it often states that there is the option to purchase the property for $100,000. The consideration is the leasing of the property. The leasing of the property is sufficient consideration upon the part of the optionee. An option must contain all the terms of the purchase similar to a deposit receipt. At the time of exercise, all that the optionee must do is state, I will buy according to the option terms. Question 10. The provision that states the realtor shall not publicly disparage the business practice of a competitor appears in the A. Real estate law. B. Commissioner's Rules and Regulations. C. NAR Code of Ethics. D. Business and Professions Codes. Answer C. This provision appears in the National Association of Realtors Code of Ethics. Question 1. Which restriction would be the most difficult to enforce by a developer of a subdivision? A. Size limitations. B. Limitations of dollar amount spent on improvements. C. Square footage of homes. D. Height of structures. Answer B. Since the value of the dollar changes, the amount of improvements that a certain dollar amount could achieve would be constantly changing and would result in differing improvement results. Question 2. In order to obtain a loan, a person would likely go to A. A bank. B. Federal Housing Administration. C. Department of Veterans Affairs. D. Department of Housing and Urban Development. Answer A. Banks are the actual lenders while the FHA and VA are institutions that guarantee all or a portion of a loan in order to procure more favorable terms. Question 3. A mortgage and trust deed are the same in which they allow A. The property to be sold in the event the borrower defaults. B. Prescriptive benefits. C. An estate in gross. D. None of these. Answer A. A mortgage and trust deed are the same in the fact that if the borrower defaults on the loan, they allow for the sale of the property. Also known as a security interest. Question 4. What does a desist and refrain order do if issued by the Real Estate Commissioner? A. Places restrictions on the sale of properties in a subdivision. B. Places a halt to sales and marketing of properties in a subdivision. C. Places a time constraint on the sales of properties in a subdivision. D. None of these. Answer B. If there is an issue with a sales program of a subdivision, the Real Estate Commissioner could obtain a desist and refrain order which would immediately halt the sales and marketing of the properties. Question 5. It is to the truster's advantage to include A. Subordination clause. B. Dependent clause. C. Independence clause. D. Reserve clause. Answer A. It is to the truster's advantage to include a subordination clause in a trust deed because it allows the truster to obtain a later trust deed which will move into prior position, as regards to payment, in case of default. Question 6. In order to have a valid agency relationship, the commission agreement must be A. In writing. B. Filed with a broker. C. Within the acceptable bounds of commission rates. D. Notarized. Answer A. The commission agreement must be in writing when forming a valid agency relationship. Question 7. The collection of mortgage payments from borrowers and related responsibilities of the loan servicer is known as A. Servicing. B. Lending. C. Collecting. D. Managing. Answer A. This type of work is known as servicing. These actions are responsibilities of a loan servicer. Question 8. The fund set aside for replacement of common property in a condominium, PUD or cooperative project is called A. Replacement Reserve Fund. B. Reserve HOA Fund. C. Interchange Fund. D. Cooperative Exchange Fund. Answer A. This type of fund is called a replacement reserve fund. It is set aside for replacement of common property in certain projects. Question 9. A commitment from a lender to the borrower or other mortgage originator guaranteeing a specific rate for a specific time at a specific cost is called A. Rate lock. B. Fixed rate. C. Lock terms. D. Fixed terms. Answer A. When a lender commits to the borrower or originator a specific rate for a specific time at a specific cost, this is called a rate lock. Question 10. A limit on the amount that payments can increase or decrease during any one adjustment period is called A. A rate lock. B. A period rate cap. C. A terms lock. D. Fixed rate. Answer B. A period rate cap is a limit on the amount that payments can increase or decrease during any one adjustment period. Question 1. If brokers of different offices agree to set commission rates at a particular level, this would be a violation of A. The J. Edgar Hoover Antitrust Act. B. The Sherman Antitrust Act. C. The Anti-Monopoly Act of 1932. D. The Sherman Antitrust Act. Answer B. Brokers of differing offices have faced severe punishment by conspiring to set rates because this is a violation of the Sherman Antitrust Act. Question 2. A lease that allows a landlord to collect money based on the amount of sales the tenant's store produces is A. Illegal. B. Called a percentage lease. C. Called a net lease. D. Called a pocket lease. Answer B. A percentage lease is a lease in which there is a base rent as well as a percentage of the gross sales is due to the landlord after a certain threshold is met. Question 3. The type of listing that is the most risky and open to fraudulent activity is called A. Pocket. B. Bet. C. Exclusive. D. Gross. Answer B. Net listings are when the agent keeps the sales price above a certain amount and can subject the broker and agent to have their licenses suspended or revoked. Question 4. When a building and a land are appraised separately, this is which type of approach to appraisal? A. Market. B. Index. C. Data. D. Cost. Answer D. In the cost approach to appraisal, it is required that the building and land be valued separately. Question 5. What does mortgage insurance cover? A. The amount of the loan in the event of the borrower's death. B. The lender in the event of a loss. C. Job loss or accidents that render a person unable to make mortgage payments. D. Incapacitation of the borrower. Answer. B. Mortgage insurance covers a lender from losses. Question 6. What does mortgage life insurance cover? A. Pays off the loan amount in the event of the borrower's death. B. The lender in the event of a loss. C. Job loss of the borrower. D. Incapacitation of the borrower. Answer. A. Mortgage life insurance covers the amount of the loan in the event of the borrower's death. Question 7. If Sam wishes to secure a real estate loan with the inventory of his furniture store, under the Uniform Commercial Code this would be A. Legal. B. Legal as long as the inventory equals the loan amount. C. Illegal because the inventory is considered a fixture. D. Illegal because the inventory can be sold and cannot secure a loan. Answer. D. Because the inventory will eventually be sold off, this is not sufficient to secure a loan under the Uniform Commercial Code. Question 8. A contract that is binding between the buyer and the seller, as well as conditional delivery of transfer instruments to a third party is required for A. A transfer of title. B. A valid escrow. C. A person to buy a house. D. None of these. Answer. B. In order to have a valid escrow, there must be a conditional delivery of transfer instruments to a third party as well as a binding contract between buyer and seller. Question 9. In the case of a cash sale, why would a seller wish to transfer an existing fire insurance policy? A. Because then they don't have to worry about a new policy. B. Because it is more convenient this way. C. Because they will not have to pay a short-term cancellation rate. D. Because there is no need in a cash sale transaction. Answer. C. Sellers are typically more likely to want to transfer an existing fire insurance policy because they will not have to pay a short-term cancellation rate. Question 10. If a Chinese person calls an agent and asks to view property in a particular area of town that is known to house many people of Chinese descent, this would be A. An example of steering. B. An example of blockbusting. C. Perfectly legal. D. Illegal. Answer. C. In any case in which a person wishes to view a property, regardless of race, this is viewed as a perfectly legitimate opportunity and should be treated as a normal client.
Exam Scholar, Real Estate Edition.